All right, let's start to our second second presentation. And in this one, we have Dr. Brook, Associate Professor Brook from University of Leeds. Let me first present her to you. She's, as I said, Associate Professor of Competition Law and Policy at the School of Law at the University of Leeds, and she's also the Deputy Director of the Center for Business Law and Practice. She has an interdisciplinary academic background, so I am assuming that she has two degrees, one from law and another from economics. I hope that I'm right on this. And she holds a PhD from the Amsterdam Center for European Law and Governance. She also holds an LLM degree from University of Amsterdam on European competition law and regulation. Today, she's going to present us a portion from her recent book, which was published in 2022 by Cambridge University Press, Non-Competition Interest in EU Antitrust Law, an Empirical Study of Article 101. I am guessing that empirical study is one of your main areas, right? So given your economic background, you're somehow combining your law and economics in empirical studies, and that's very valuable. And we if I'm not mistaken, we were in contact with you in 2019 and 2020, and you were going to present either this topic or very close to something very close to this one at the time, but there was pandemic, unfortunately, and we couldn't host you. So after 4 years, we are hosting you here. Thank you for being with us tonight. I think these two topics really match today. And after your presentation, our audience and me and everyone, I hope, will be very much informed about the issue, both from the theoretical and from the empirical side. And thank you for coming here again. Floor is yours. You have 40 minutes. And after that, we have like 15 minutes of Q&A, if everything is okay.
Yeah,
Please.
that's perfect. So thank you so much for the invitation. As mentioned, I will present some insights of the book. You have a QR code here for the book itself. I understand that your university do not have access. So I also shared some articles that touch upon some of those topics that you might have better access to. So what I want to do today is talk a bit about the context of non-competition interest or public policy considerations in EU competition law. In preparation for today, I also read up a bit about the Turkish competition law regime and got this helpful book a few months back. So we'll try to link it to some of the discussions in Turkey. But my background in Turkish competition law is very limited, so I would love to hear also your insights in the part of the discussion. After this general introduction and possible some overlaps with Professor Coliono's presentation, I'll present a bit about the project behind this book, which took quite some time to compile, and the empirical study and the empirical methodology that was used. I will present some of the findings, of course, quite limited because of the time frame, and discuss some recommendation, and again, trying to link it to some of the discussions that might be relevant for Turkey or similar jurisdictions. So to put this discussion in context, I would like to consider the example of the Dutch power plant case, again, taking us to the Netherlands. In 2013, different parties from the energy industry in the Netherlands came together with government and civil society organization to conclude an agreement for a more sustainable energy production throughout the Netherlands. As part of their agreement, they decided to accelerate the closing down of 5 coal-fired power plants in the Netherlands. The agreement clearly aimed to achieve an important environmental goal, reducing emissions. Yet it also carried clear anti-competitive effects. The coordinated closing down of those plants would disrupt the regular course of the markets and would have likely to result in a significant increase of energy prices in the Netherlands. This reason, the foreseeable increase in prices led the Dutch Competition Authority to prohibit this agreement, saying it amounts to a cartel that is against both EU and Dutch competition laws. This case, like many examples, especially in the area of sustainability, but also other areas, show example about the interaction between competition and non-competition interests. If we go a bit back in history to Adam Smith, the founder of modern economics and as such also modern competition laws, Smith was not too keen to leave room for almost any type of non-competition interests. This is a very famous quote of Adam Smith, where he labeled the restriction of trades for public policy reason as asphyxiation, a false claim, believing that only very few words need to even be deployed to discourage this type of behavior. And if you take this reasoning, probably there should be no room for public policy considerations, period. Although, as we all know, Smith's work has fundamentally inspired the economic theory underpinning competition laws across the globe, when it comes to the EU state of affairs, much ink has been spilled on the question of what should be the role of public policy, what kind of public policy should be taken into account, and how. In fact, if we go back to the EU treaties themselves, 1957, they acknowledge that non-competition interests may play a role in the enforcement. Accordingly, while Article 1011 prohibits almost any type of anti-competitive agreements, Article 1013 leaves some rooms to exempt agreements that fulfill those four conditions. Article 1013, and I've seen that the Turkish competition law adopted a very similar model and is clearly inspired by this model, is based on an old French competition law that was in time when the Treaty of Rome was signed. And in turn, this French law goes all the way back to the Middle Ages. So a lot of the terms that are being used are not based on solid economic policy, but more on vague legal concepts, and probably are not necessarily well set to some of the contemporary discussion that we have about the role of public policies. For example, when it comes to protection of data, digital platforms, and so on. When we look at those four conditions, although Article 1013 suggests that there is room for non-competition interest, it does not detail the precise role of the competition interest or the legal economic tests that should be used. For example, while we might understand what we mean by improving production or distribution of goods, what is technical or economic progress? What is fair share? How do we apply this responsibility? As was raised in the previous discussion, how do we balance between quality and quantitative types of benefits? When we think of examples like the environment, but also animal welfare, employment, culture, innovation, Article 1013 does not give us a decisive test for this type of balancing, and in the end, it often remains a matter of policy. And we see that this policy differs from one jurisdiction to another within the EU, outside of the EU, and jurisdictions use the very same test. From the beginning of the enforcement of EU competition law, so the early 60s, up until the late 90s, the Commission and EU courts have repeatedly endorsed a very broad interpretation of Article 1013, which reserved a large room for non-competition interests. In fact, all of the non-competition interests that I mentioned in examples in the previous slides have been taken as relevant for the application of Article 1013. The EU courts, the Commission repeatedly emphasized that EU competition law is not an end into itself, but rather an instrument for achieving the EU economic and social goals. This is a nice citation for the Commission annual report saying that Article 1013 is more than just a means to lift the ban of restrictive practice. It also gives the Commission an opportunity to create cooperation possibilities for firms and to implement industrial plans to increase the EU competitiveness more generally. This type of broad role for Article 1013 also well suited the enforcement regime that was at the time, the notification and authorization system in a central way. So up until 2004, while Regulation 17 was in force, all anti-competitive agreements or potentially anti-competitive agreements were notified to the Commission before they were implemented, and the Commission could either approve them, reject them, but in more cases than not negotiate with the undertakings their specific terms. And this allowed the Commission to embed non-competition interest in the enforcement, to give undertakings clarity beforehand on whether or not those public policies are relevant, and to try to tailor it again to the EU industrial policy and more greater aims. Because of that, the debate about the role of non-competition interest was revived around the turn of the millennium, when the Commission started to call to reform the enforcement regime that was finally implemented as a modernization of competition law by Regulation 1/2003. This reform, which is known as a modernization of competition law, has 3 pillars, and each one of those pillars has changed or affected the way that non-competition interests can or should be taken into account. And the first pillar of modernization, known as a more economic approach or the substantive modernization of competition law, the Commission changed the interpretation of competition policy from a legal formalistic approach to a more economics-based assessment. This economic-based assessment is and was inspired by the Chicago School, by the idea that efficiencies and consumer welfare should be the main focus of the enforcement, meaning that there's only little, if any, room for broader public policy considerations, especially if you cannot quantify them in economic terms. Again, this is a nice quote saying that Article 113 is intended to provide a legal framework for an economic assessment of restrictive practices and not to allow the application of competition rules to be set aside because of political considerations. This is one of the Commission aims in its modernization white paper. However, this change is not only ascribed to economics or to theory, but also to a more practical concern. As part of Regulation 1, the enforcement was decentralized, shared together with the national competition authorities of the member states. If we look back at the history and the discussion of Article 113, we can also see some indication that the new narrow interpretation was endorsed by the fear that some member states, yes, we are looking at France probably, and also some of the new Central and Eastern European member states that joined the EU at the same year, will use Article 113 in a protectionist way in order to protect their own national firms or in order to protect their own national markets rather than to promote competition. And by limiting Article 113 to those limited economic quantifiable efficiencies, this was seen also as a safeguard against this national protectionism. Finally, the third pillar of modernization was a self-assessment regime, moving away from the centralized notification ex ante assessment to a self-assessment regime where undertakings need to self-assess their own behavior and in particular to decide themselves if their agreements can be justified on non-competition interest grounds. Because we have a self-assessment regime, we do need a bit more clear rules that undertakings can assess in advance. And this is another reason that could be to limit the type of interest that can be taken into account. The combination of those 3 pillars of modernization led many of the scholars in the field to conclude that the modernization of competition law has reduced, if not completely eliminated, the role of non-competition interest in the enforcement of Article 101. In this book, in this project, I offer an empirical evidence to challenge this common view. And I will try to convince you today that actually the modernization might have increased the role of non-competition interest. Before moving to try to prove that based on empirical data, a bit about the project and how I went about to examine this question. So this book aims to address those 3 research questions. The first one is really empirical or doctrinal to try to map how have the rational method and limits for the balancing of competition and non-competition interests changed over the first 60 years of its existence. So from the 60s up until 2017, which is the cutoff date for this study. The second part is to try to assess how this process affected the objective of the enforcement. So Regulation 1/2003 flags effectiveness, uniformity, and legal certainty as the main goals of competition law enforcement, to try to see if that was met, and a normative part of what role should non-competition interests play in the future. In order to do that, I applied systematic content analysis, which is also known as coding, of all Article 101 public enforcement proceedings, appeals, preliminary rulings, involving the EU Commission and courts and 5 member states. So the UK was still a member state at the time, France, Germany, Hungary, and the Netherlands. And for the national enforcement, I looked at the period after decentralization up to 2017, and also included the application of their purely national laws rather than just the EU competition law cases. I tried to take a very broad approach to look about any public information about enforcement, so not only formal decisions, but any information in press releases, public announcement, annual reports, and so on, and also including informal guidance and procedures. This QR code takes you to another article to talk about systematic content analysis and coding a bit more if you're interested. But in a nutshell, so this is, first of all, sorry, that's the whole database. You can see it covers 3,101 cases between the Commission, EU courts, and the national enforcers. And when we say coding or applying systematic content analysis, this is the outcome or the output. You can see it's an Excel spreadsheet where every row represents one case, and every column represents one variable, so one aspect of the enforcement. For this project, I think it was around 40 variables. So some of them are about case identification, the name of the parties, the courts, the dates, some information about the undertakings, then variables talking about the type of non-competition interest that will raise in the case, if it was raised. So I coded here the type of interests. Are we talking about environmental considerations, employment, protection of data, and so on? But also I coded the normative status. So does the Commission or the court identify this interest as being an EU objective? Is it part of the treaties? Is it the national interest? Or in most cases, not explaining the normative status at all? Then there are a few variables discussing balancing instruments under Article 101(1). So if we go back to the previous presentation, to the example like the Wouters Doctrine, ancillary restraints, rule of reason. A lot of variables about Article 101(3), so each one of the tests, whether it's accepted or not. Then we have other information, so whether Article 102 also applied to the case, free movement rules. Was there any discussion about consumer welfare and how that should be interpreted? Was there an economic crisis at the time being invoked as a good reason, and so on? And then finally, information about the outcome of the case. So was the case closed by an infringement decision, commitment decision, imposition of fine, and if so, what was the level of the fine? The coding of these cases, or how this Excel file was filled, was based on a coding book. So for each one of those variables, the coding book predefines a closed list of value labels. So for example, if we look at one of the variables, what is a consumer in the meaning of fair share to consumers in Article 101(3), you can see here different interpretations. And then for each case, I tried to show how it was interpreted by the court, commission, or the national decision. The reason that I thought that this type of methodology is appropriate to examine this question is because many of the previous contributions to this topic, and this topic has been heavily debated also before, were mostly theoretical based. So try to say, should we take into account, shouldn't we take into account, but they didn't really focus on systematic mapping of previous case law and the different approaches. By using systematic content analysis, we can code discretion to see how the different competition authorities interpreted the rules, how they decided to go about applying each one of the tests. It allows us to code the visible cases, so the cases which are in the database, and for them to look at what I label in the book as explicit substantive balancing tools. So it's things like Article 101 balancing tools, Article 113, where the competition authority explicitly declares that it is balancing competition and non-competition interests. For those cases, we look at the type, we can see the type of relevant non-competition interest, what was the balancing method, what was the intensity of control that was applied when applying those tests, and how frequently they were used and accepted. But one of the biggest power of systematic content analysis is to look at the dark matter of the enforcement, which I call in the book implicit procedural balancing tools. In other words, other ways to take into account non-competition interests, which are not explicit and we cannot see them if we only focus on specific cases. So more specifically, I say that if we look at the core, so the white core, the cases were decided on the merits, and that we have reasoned decisions regarding the balancing, we can also try to make some, to draw some conclusions with respect to the cases were not investigated, not detected, and that are still out there, but still took into account somehow public policy considerations. And I will try to explain more details as we look at certain examples. In terms of the contribution of the book, so as far as I know, it's the first time that empirical bottom-up approach was taken to try to map out the role of non-competition interest. It allows us to look at new balancing tools. So in addition to Article 101.3, block exemption regulations in Article 101, the book also shed light at unique national exceptions different national competition authorities adopted and might deviate, if not conflict, with the EU competition law approach. How non-competition interests are being taken into account when setting the remedies. So it could be either reduction of fines or accepting commitments in order to tailor them for public policy considerations. And this is something that I also developed in future work, is enforcement discretion. So how the decision of which cases to choose, but more importantly, which cases to disregard, also allows and tailors the room for non-competition interests. So I'm just looking at the time. Let's quickly try to go through some of the findings. And just as a reminder, I'm trying to prove that the modernization of EU competition law has actually increased the role of non-competition interest and definitely did not eliminate. So probably the first starting point to look at this trend is to look at the application of Article 101.3 by the Commission throughout the years. So you can see here, so the first upper black line represents all of the cases where Article 101 TFEU was examined by the Commission from 64, the first case, up until the cutoff date of 2017. The gray dotted line represents all of the cases where Article 101.3 was argued as a defense against the anti-competitive behavior, and the yellow bars represent all of the cases where exemptions or exceptions were granted. So at first look, it actually seems to confirm the kind of common view that the modernization of competition law in 2004 reduced, if not made Article 101.3 a dead letter, as being said by many. However, I think that the picture is a bit more complex, and we can see it maybe if we dive into looking not at the yellow bars, but actually at the gray line. So the number or percentage of cases where Article 101.3 was argued by the undertaking as defense. Here we can see that up until 2004, in around 57% of the cases in average, undertakings have invoked Article 101.3 as a defense. In 2004, and it happened straight away after the regulation came into force, this percentage has dropped to only 25%. So essentially in one day, Although the question of the interpretation of Article 101(3) remained open-ended and vague, undertakings, but if we read more realistically, the lawyers of the undertakings have decided to almost stop invoking Article 101(3) as defense, and not even to try to argue that non-competition interests can be taken into account. How can we explain that? So what I suggest that we can explain this shift if we look at the type of cases that the Commission choose to focus on after modernization. This graph shows that after the modernization, the Commission has taken a conscious choice to focus its enforcement mostly on hardcore cartels. Those hardcore cartels were also identified mostly by leniency settlements, in many leniency applications, mostly with leniency settlements. And the other cases, so the classic type of infringement decision, remain a clear minority of the enforcement focus. Hardcore cartels, and especially secret hardcore cartels that are eligible for leniency applications, are by their very definition unlikely to raise genuine or semi-genuine public policy considerations. We don't imagine that undertakings come together in a smoke-filled room, secretly conspiring how they can save the environment, right? It's unlikely that those are the cases we focus on. We see that there are a significant amount of cases where Article 101(3) was raised that were settled by the Commission by means of commitments. Formal commitments are commitments under Article 9 of the regulation that are very formalized and proceduralized. But also we have informal commitments where the Commission decides to close an investigation upon receiving commitments. We don't have a lot of information about those cases because they're often not fully published and not reasoned. And that's the same true for the cases that were just closed. But once again, if we look at the classic enforcement of Article 101(3), I can actually see that a huge portion, so around 11 out of 16 of the cases, actually raised Article 101(3) arguments, even if they were declined. We can see very similar trend if we look at the cases where Article 101(1) types of balancing tests were examined, or block exemption regulations were examined, which are two other ways to take into account, two other explicit substantive balancing tools, which I have a chapter for each in the book, but I will not expand on today. I think that this argument or the idea that the Commission justice does not take cases where non-economic interest the non-competition interest might be relevant are also reinforced when we look at national enforcement. So this graph depicts, again, all of Article 101(3) procedures from the decentralization to 2017. And each row represents the number of cases where Article 101(3) was invoked. So it would be the left-hand side, and the number of cases where this exemption was granted. The different colors of the bar represent the type of non-competition interests that were examined. And here you can think of a scale from going from direct economic costs, so it's the core of efficiencies or the core of what Chicago School would probably accept, all the way to non-economic interests that are not related to a specific product, a specific market, like general animal welfare or general societal benefits, which are here in red. Here we can see that there are different approaches. So certain competition authorities like the Commission, like the UK, have not even examined those types of non-economic considerations. Where a case, so the question is why? They only looked at economic efficiencies. When discussing this and showing this statistics to some people working in those jurisdictions, they said, yes, when we see a case where public policy considerations come up, we often just close it without taking any decision and any publication. And this could be one of the reasons that we don't see this kind of discussion about the role of public policies. And we don't see cases where Article 101(3) was invoked, and especially when it was accepted. The other type of the cluster of authorities like French or the Netherlands do leave room for non-economic benefits. So in France and the Netherlands, the cases in red that you can see did involve very broad types of public policy considerations like animal welfare, sustainability, employment, fair trade. And those authorities have never said that those types of benefits are not relevant. Sometimes they did not accept those benefits in a specific case, but they did leave room for these considerations. In Germany, that's a bit of a side finding, but quite interesting. The authority actually accepted some public policy arguments based on the other category in blue, which represent cases where the state has played a role in the enforcement. Many other jurisdictions will examine that under the state action defense, but in Germany, they interpreted it as part of Article 1013. In the book, and this is the final chapter of the book, I tried to map out different ways of balancing between competition and non-competition interests using enforcement discretion. And here I tried to order it according to 4 types of discretions. We have detection discretion, and this is what kind of cases are likely to be even noted by the Commission. Because the Commission and many of the national competition authorities mostly use reactive strategies, so based on leniency and settlement applications, they're unlikely to investigate or even be aware of cases where public policy, genuine public policy considerations might play a role. Second type is target discretion. So the question of what are the declared prioritization powers of each competition authority? Do they declare that they want to focus on hardcore cartels? And is there room for cases that actually promote other types of policies, like a focus on sustainability or inequality, reducing types of cases and sectors? There's a question about instrument discretion. So here the question is, what kind of tool would each competition authority take? Would they use Article 101, or would they use sector regulation, market works, which is sector inquiries? Would they use informal ex-ante opinions? There's also a question on how the effect on trade test was applied, but I'll not expand on it today. And finally, enforcement discretion can also be informed the type of level of fines that will be imposed, whether or not a commitment decision will be accepted, and whether or not to adopt inapplicability decisions. The decision declaring that Article 101 is not applicable to a certain type of behavior. In the book, I show statistics for each one of those type of balancing by enforcement discretion, or each one of those types of implicit procedural rules. For today, I can give you just one example of balancing in commitments. So this graph, once again, depicts all of the commitment decision in each one of the jurisdictions after decentralization until 2017. And what is quite striking, that almost all of the commitment decisions in each one of the jurisdictions have been adopted in one of those 3 sectors. Either highly regulated sectors, which are the shades of blue, in technology markets, which are the shades of green, or in financial services, which are in red. The other type of sectors, which are in gray, is really a small minority in most jurisdictions, with the exception of Hungary. What this might show, that commitment actually replaced exactly the type of sector, to address the same type of sectors that up until modernization were examined under Article 113 exemption decisions, where the Commission could negotiate with undertaking the terms. When it comes to following modernization, because self-assessment is not well suited to tailor this balance between competition and non-competition interests, when we have questions about how access to energy and transport, how public health and safety should be balanced with competition, how technology markets should be addressed, the Commission and the 5 competition authorities that I examined prefer to use commitments rather than infringement decisions, because the scope of Article 101 is not sufficiently tailored. What I show in the book is a conclusion. It's true for the Commission, but also for other authorities, that there is a shift following modernization from explicit substantive tools, which take head-on the question of how to balance competition and non-competition interests, to implicit procedural balancing tools, which the decision itself does not discuss what should be the role of public policy, but rather leave it to the question of enforcement discretion. This leads us to my recommendations. So I argue that this shift from the explicit substantive to the implicit procedural tools actually reduces the effectiveness, uniformity, and legal certainty of competition law. Because we move from substantive explicit to implicit procedural tools, there is no clear legal test of when can the Commission or another competition authority close a case, or what kind of cases they can focus on. Is it justified to focus on a cartel instead of, for example, the environmental types of cases? Because we mostly focus on procedural implicit decision of whether or not to enforce a case and by what tools, it also means that there is less EU centralized approach and more discretion for each member state to adopt their own procedure, own discretion, meaning that there's less uniformity. Finally, we can also see a shift in the role of the EU courts. So while the EU courts were quite explicit about the role of public policy and the broad scope of EU competition law before modernization, after modernization, because there are not a lot of cases appealing the Commission's decision whether or not to take a case, whether or not to take into account public policy considerations or applying Article 101(3), that also means that the courts have less opportunity to discuss and develop the EU approach to this question. There are only a few cases where we can see whether or not the EU courts have accepted the more economic approach, and more specifically, how it interpreted the more economic approach or the limits of the consumer welfare standard. This leads to the final conclusion that while non-competition interests have and will always play a role in the enforcement, in my opinion, instead of asking whether they should play a role, we need to question and focus on how they should be taken into account in order to respect the different objectives of Regulation 1/2003. I'm happy to expand on that also in the Q&A a bit more, but I advocate that competition authorities should adopt a more diverse portfolio of cases. So while cartels and fighting cartels is an important cause, they should also take into leave room for discussion of cases discussing the role of public policy. We need to shift back to the substantive explicit tools. Here, I think that the Turkish competition authority development is quite interesting. So from what I read, and correct me if I'm misunderstood, in recent year, the law was changed to allow to take non-competition interest, to close cases for commitments, but also to adopt positive decisions and to adopt to give informal advice to undertakings, which I think is a positive development because it allows for this kind of discussion rather than just hiding it off under enforcement discretion. This will force or invite competition authorities and courts to take a more clear approach to the role of non-competition interests, which will lead to both judicial review, but also to public review and discussion about what the role should be, and will lead hopefully to respect of Regulation 1/2003, but also more broadly to respect the rule of law and to have a more coherent and uniform and legal certain enforcement regime, which is probably a common and shared aim of all competition law systems, at least in democratic jurisdictions. So reviewing all of the findings will certainly require a bit more time, but if you're interested, again, this is the link to the book. Please do feel to get in touch if you have any questions or comments also after the presentation, and I would looking forward to the questions and debate.
Well, thank you very much. This was a lot of work, I'm sure. And the first thing that we should do at the university is probably we should get your book to our library. Unfortunately, we don't have it at the moment. Probably due to budget constraints. I don't know why. And thank you very much, really. Now I turn to the audience, to the floor, and if you have any questions, you can just raise your hand. And is there any questions that we want to?
Sir San, can I have some words for?
Yeah, sure. Go on.
So, Professor Brook, thank you so much for coming, and it's a huge pleasure to have you here. So, I have a question and a comment, maybe. Actually, as you mentioned, I think we have a similar situation in Turkey also. After settlement mechanism introduced in Turkish competition law, I think undertakings do not want to defend the cases, especially in Turkey example, especially RPM cases, because Turkish competition authority has a very harsh application of RPM lately. We can say that. Instead, the undertakings lean on acknowledge the possible breach allegation and want to get decrease in fine. So I think competition law mechanisms like leniency, commitments, or settlements, I think may also prevent the development of jurisprudence on how new theories of harms will be handled by the competition authorities. So what I wonder, what do you think about this?
Yeah, so I completely agree, and that was also one of my insights coming out of this project. A few months ago, I just put it in the chat, and this is open access, so you should have, that should be easy for everyone. I published a follow-on study with the Journal of Antitrust Enforcement, in which I tried to map out how the Commission, German, Dutch, and UK competition authorities created the portfolio of cases. And I completely agree with your conclusion. So I show that once they introduce settlements and leniency applications, the vast majority, we're talking about 85, if not 90% of the cases were settled by what I call negotiated penalty settlements. So either settlements and or leniency applications. I find it highly problematic. I mean, I think you were generous with the competition authorities and you said undertakings prefer to settle the cases. I think that in many cases, it's also the competition authorities prefer to settle the cases. I think especially when we're talking about gray areas of the law or cases where you have public policy considerations and you might have PR nightmares if you take this case, competition authorities as well as the undertakings will prefer to settle the cases or to limit the scope of the discussion and to make sure they will not be subject to judicial and public review on the account of limiting the development of the law. I haven't discussed it in today's presentation, but in the book I show that in the Netherlands and France, where the competition authorities have much more limited discretion to choose whether or not to take the case. So they have to take cases that come into their attention. There's much more discussion of those questions. Personally, sometimes I disagree with, especially with the Dutch competition authority, which I find to be quite lenient, and sometimes they base their decisions on tests which I oppose to. But at least they discuss about it, right? They take a chance, they write guidelines, they test certain type of approaches. If we don't have that, and in many jurisdictions we don't, because we base ourselves on leniency applications and settlements, then we lose the law. And
I think we should do the same research in Turkey also after those mechanisms introduced in Turkish competition law. I think it will be a great research. Thank you so much.
Yeah, I mean, that would be fascinating. I think in Turkey, again, from what I saw, you had so many different reforms. So switching to self-assessment, then introducing commitments, introducing settlements, introducing a negative decision. So it'd be very interesting. If you do that, let me know. I would love to see.
For sure. Thank you.
And the interesting thing about these new institutions is that they are widely used. I mean, just to give you a idea about how pervasive that they are used. This year, I mean, somebody can correct me on this perhaps. We have 60 in 2023. We have 68 settlement decisions, and around 30 or 28 cases on
RPM.
No. It's on. It should be on commitments. So most of the cases are ended with the new procedures. So we don't observe the usual process of allegation, defense, report, and infringement, or whatever the decision will be. And this somehow changed the way in which Turkish competition law evolves at the moment. And what is even more important here, and it should be noted, that we have now less and less judicial review due to these processes. And I don't know the effect of this on public policy goals and arguments, what's going on there, because those procedures are not transparent. But I'm sure that it will have it has a huge effect on the evolvement of Turkish competition law, and then, well, it's definitely a very promising area for empirical research and even theoretical research. So the numbers are very interesting. I mean, I don't think that in any other jurisdictions we have that proportion of cases where the cases are ended with these new mechanisms. I don't think so. I mean,
so in the paper I shared, I actually showed that yes, in Europe those are the common percentages. And what is quite interesting, and I completely agree with you, that we see this push for those mechanisms also from international organizations. So the OECD, ICN, ECN, trying to push more and more of the use of those mechanisms, while not really discussing even the impact on the development of the law, and especially about the role of public policy considerations, which I think is
okay.
Yeah.
Thank you. We have two other questions. We start with Kadir. Kadir.
Thank you very much, Hocam. Thank you very much for presentation as well. Today we discuss whether competition authority would permit an agreement based on non-competition benefits or non-economic benefits. But there may be certain situations where an agreement or a transaction may not harm competition interests, but non-competition or non-economic interests. We saw this in merger cases. In a merger cases of two book publishers, Commission said that because of this merger, there may be a reduction in the diversity of books. And it considered as a harm, as a competition harm. So I was wondering whether you made a tremendous amount of research. I was wondering whether have you seen any case like this? From economic perspective, the agreement may be okay, but it may harm, for example, media, diversity in media or other concerns, and any competition authority didn't allow a merger. Or I am talking about merger because there are more issues, more cases in that area of competition law. But whether there are cases have you found in terms of application of Article 101?
Yeah, this is a great question. So let me start with the nerdy coding methodology answer. I coded all cases, but I coded the variables about the balancing tools only for cases where non-competition interests were used as a defense, as a shield. I initially thought should I use them as a sword, but I think it's more implicit and different, so I haven't done that. But to answer to the substance of the question, what I also did in the book is try to map out enforcement discretion. So what kind of cases, sectors, types of restriction of competition did the Commission and competition authorities examine throughout the years? And if you take this perspective, I think we can see the trend that you are referring to. For example, and I think it's quite well known, in the early years of competition law enforcement, the Commission focused on cases of vertical restrictions, which mostly impaired market integration, and where the harm to competition, or at least as we understand competition in the past 20, 30 years, was minor, if not existed at all. So this could be one good example. In more recent years, I think it's more a question about priorities. And one example that I came across were models agency cases. So you have cases about possible collusion of contracts for models. Quite minor. The question, is there competition law concern? Maybe, maybe not. And then nonetheless, then 5 competition authorities in the EU decided to take the case. Yeah, we can think of different reasons why they decided to take that and to focus so much resource. It was closed by commitments. But it's more nuanced, especially because most of the cases by the end of the days are hardcore cartels by leniency and settlements, right? And if you take a reactive policy, you don't have a lot of room for the type of cases you mentioned.
Thank you very much.
Thank you very much for the question and the answer. Do we have another question?
Mr. Köksal have a question also.
Okay, Artekin, please.
Dear Professor, first of all, thank you for your insightful presentation. I think it's an invaluable study to engage with, and it's quite important. And as you said at the end, that it would streamline the approach of the competition authorities, especially in the EU and outside. And not in the framework of your study, but I would like to ask a question regarding the US approach and the EU approach. So while you are conducting this research, did you find any concrete differences between the US approach and EU law? And also, is there a cooperation between them? As you all know, in digital markets, especially in globalized markets, like vertical and also horizontal agreements are an issue on a global level, not a national level.
Yeah, of course, and another really relevant and important question. So my study focused on the EU and also taking a systematic approach and looking at the institutions of the EU. The EU approach is, of course, heavily inspired by the US, and especially the shift to the more economic approach. And if we look at the early cases of the EU, late 90s, early 2000s, we see the very strong US influence even explicitly. The US system today is quite different for a lot of different reasons. But I think one of the important, for the purpose of my study, is that 90% of the enforcement of antitrust law in the US is done in private cases. So the public enforcement in the US is very limited. They have the discretion to which cases to choose and which to disregard is almost unparalleledly unstructured. So not only the law does not tell them which cases to take, but also they do not adopt any guidelines. So we don't see this approach. And perhaps because of that, because they have so much discretion to choose which cases to pursue and which disregard, they have almost no discussion about the role of public policy in the actual enforcement. So formally, they're taking a very strict approach, consumer welfare, which is much more developed in their jurisprudence of what they mean by consumer welfare. And I think, as was mentioned before, it's closer to total welfare, really hardcore efficiencies, and almost no discussion about balancing or taking into account wider considerations. This can also relate to the historical legislative and constitutional normative stance of antitrust in the US. So they have the constitution above the antitrust laws. In the EU, competition and other public policies are all in the EU treaties, so it's a bit more complicated. So a lot of different considerations, both in the theory and the practice of how it's been applied. So I'm not sure I answered your question, but I think some of the things to keep in mind.
Thank you so much. I mean, also the other point would be on the corporate cooperation between the US officials and EU officials.
You mean investigations where?
Yeah, on settlements regarding settlements, let's say.
Yeah, I mean, we do see those kind of cases, right, where they were first settled or litigated in the US and then they're being settled in the EU. I think from the perspective of public policy considerations, they're less interesting just because their leniency in settlements, once again, and probably do not involve genuine or significant public policy considerations.
Thank you so much.
Thank you very much, Artekin, and thank you for the answer. Is there any other question from the audience? I think that's it. I was wondering, so you have analyzed the cases and you have looked for the public policy arguments or perhaps non-economic, non-efficiency considerations. What was the most, used or most frequently used public policy arguments by the parties, or which one of them are mostly accepted by the Commission or the competition authorities in those jurisdictions that you mentioned?
This is really great. I should know that. I mean, I definitely have graphs on that, but I don't about when they were invoked. But I'm more focused on how they changed throughout the years rather than the total number, because I'm looking at quite a broad time scale. I will send you the graph once I find it.
But
I mean,
as you can recall, what do you recall?
In more recent years, we can see that sustainability is, of course, a very big one. So both, if we look at the 90s, it was mostly about reduction of emissions.
Reduction
of emissions, which were popular in the 90s. The last few years, we see more discussion about animal welfare, fair trade. You have many cases about, can we take into account the benefits to third country nationals in Africa or South America? And does that justify increase of prices for European consumers? And the question is, what is fair share in this sense? We have a lot of recent years about employment considerations. So how to regulate the gig economy, people with temporary contracts or substitute workers. So if I need to kind of just without looking at statistics, that's probably the trends of the last 10, 20 years.
Right. Thank you very much. And we have another question from Dilan. Perhaps the final question. Dilan, please.
Hello from London. Good evening. It was a great presentation. Thank you so much. And I think as an aspiring PhD student, it was a great example of how to structure an empirical research question. So thank you for that as well. And I perhaps missed first a few slides because I was working. But essentially, I don't know if you were able to follow the first presentation, but second presentation answers the questions in the first presentation by saying that these interests or policy objectives are already taken into account, not by hard enforcement, but by true soft instruments like leniency and commitments. So I'm just wondering how your research looks at or informs the current debate around equipping competition authorities with even more tools and powers, particularly the DMA debate and everything else. So, like, is the answer? It's just I'm not sure if the answer is that simple. Is that like everything is taken care of and we don't need any more tools? And I'm really wondering how you look at this. Thank you so much.
Sure. So thank you so much for the
Thank
kind
you.
words. This book started as my PhD project, so I'm glad it inspired you. And if you are interested in empirical research specifically, please get in touch because we're doing a lot of programs in Leeds and others. So really feel free to get in touch. Answering your question, I will promote another article. I'm sorry, just especially because the book is closed, then I'll send you open access stuff. So this, and I'll also send the link, is another paper where I suggest that actually the best way or one interesting way to approach this is to go away from soft law and away from enforcement discretion and use block exemption regulations. It's quite controversial because block exemption regulations have terrible reputation for good reason, because they were populistic and protectionistic in the EU in the past. But I think that and I will summarize a long argument with a few points, I think that if you are being very explicit about the role of public policy, so for example, the EU Commission took shared its approach about sustainability agreements as part of the horizontal guidelines and adopted specific guidelines about employment workers. But the problem with those guidelines that they're very vague. So even after reading all of Article 101 cases, and I can say that I did it, I wouldn't know how to apply the guidelines to a specific case. I think it's very helpful for the Commission to explain why it decided, but you can use the guidelines either to accept or reject an agreement, and there are sufficient room for both approaches. The member states did ask the Commission to adopt that as block exemption regulations, and the Commission refused. I think that if the Commission would have taken it as block exemption regulations are explicit. They need to be very clear. They're adopted for a specific amount of time, so between 5 to 10 years. After that, you have to take an impact assessment and review them. And if you take this approach, yeah, you might get it wrong in the short term, but at least you invite public scrutiny, public debate. If you adopt block exemption regulations, the Parliament needs to be part of the discussion. And because we're talking about policy arguments and not just pure economic competition law concern, I think the Parliament should be part of it, even if it is a bit populistic, but it is a decision about how to shape markets, how to create certain, how to shape industries and sectors. I mean, guidelines are better than not doing anything, just leaving it to enforcement discretion. But guidelines are problematic, especially when you look at the EU context, because guidelines are binding only on the Commission, not on the member states. We see that the member states do deviate from guidelines. For example, they clearly deviate from Article 101 free guidelines of the Commission. They're not binding in national courts or civil actions. So I think it's insufficient for them. What do you think? Do you have like a specific mechanism in mind?
So I understand like discretionary power is problematic from a legitimacy perspective. So we definitely need maybe a more structured approach. And I don't know, for me, I mean, maybe DMA is the answer.
Sorry, I forgot to say that. Yeah, so I think that DMA is actually very similar to block exemption regulation, right? In the sense that it's a regulation, first of all, meaning it went through the democratic process. It's explicit and a bit ex ante. So you take the decisions ahead and not only responding to specific agreement where the undertakings had to self-assess. So yeah, I think the DMA once again leaves a lot of room of discretion on how to interpret it, even how many gatekeepers to designate. I heard before it was implemented, the Commission thought of 20. So if you kind of impose the DMA to all semi-big companies, it's a very different result. But I do think it might be a step in the right direction, rather than leaving those cases to commitments and kind of backroom negotiations that we don't know about.
Thank you very much for your excellent presentation. And it was very nice to have you here after 4 years of delay. I hope that we can host you here in Istanbul in person in the forthcoming years.
Thank you, everyone.
Thank you so for coming, and good night, everyone.
Thank you very much.